This is the Marshall Enterprises presentation. Peace, family. Welcome to Bud-Brownsville, LLC, YouTube channel. This presentation is going to be a very popular one. I did a lot of information gathering over the last couple of hours in between the last video and this one. You're going to really enjoy this one. It's regarding Maxims of Law. I've shown you some information earlier with the Father's Rights video, but this one is going to tackle commercial maxims, equity, and quite a few other ones. So strap in, get ready. If you haven't clicked like already, click it now. If you haven't clicked subscribe, click it now. Let somebody else know you're watching this. Share it. Let's dig in, people. I'm going to share my screen so you can see what I see as I read what I read. Let's go into the maxims of equity first. The 12 equitable maxims. 1, equity will not suffer a wrong without a remedy. 2, equity follows the law. 3, where there is equal equity, the law shall prevail. 4, where the equities are equal, the first in time shall prevail. 5, he who seeks equity must do so. He who seeks equity must do equity. 6, he who comes into equity must come with clean hands. 7, delay defeats equities. 8, equality is equity. 9, equity looks to the intent rather than the form. 10, equity looks on that as done which ought to be done. 11, equity puts an intention to fulfill an obligation. 12, equity acts in personam. It's personal. It's between individual person. Okay? And that was the 12 equitable maxims. Now, where's my commercial maxims? It's down here. We're going to scroll down. We're not going to stay up here where the cursor is. A workman is worthy of his hire. And you will find it in these different Bible verses. All are equal under the law, and prerequisite places to find that. In commerce, truth is sovereign. For truth is expressed in the form of an affidavit. 5, a matter must be expressed to be resolved. These are the maxims of commerce. Commercial law, sorry. 6, an unrebutted affidavit stands as truth in commerce. 7, an unrebutted affidavit becomes a judgment in commerce. 8, he who leaves the field of battle first loses by default. Or he who leaves the field of battle first and does not respond to an affidavit loses by default. 9, sacrifice is a measure of credibility. 10, a lien or claim under commercial law can only be satisfied by one of the following actions. And those actions are a rebuttal, affidavit of truth supported by evidence point by point, payment, agreement, a resolution by a jury according to the rules of common law. All right? So that is the maxims of commerce. I've read to you first the maxims of equity, and now we're going to go into the meat of the conversation. Now, these documents, of course, will be linked in the description, below. And let's get cracking. Now, this is 21 pages long, and I'm only going to read from the highlighted portions. The author of this is Richard Anthony. It's Maxims of Law, and it's very extensive. Really bypassing all the filler. Okay, this is accidents and injury, the accidents and injury section, and we're reading the Maxims of Law. Whoever pays by mistake what he does not owe may recover it back. But he who pays, knowing he owes nothing, is presumed to give. Taxes, IRS. No man ought to be burdened in consequence of another's act. Wrong is wiped out by reconciliation. When I read this one, I thought about the guy was it South Carolina? The individual that went into the church and shot up everybody, and they forgave him. See, they forgave, but that wasn't reconciliation. But that's what, I don't know why they came to my mind, but I thought about that. But reconciliation, strong word. Look it up in the law dictionary. Look it up in the law dictionary. Reconciliation. Here we go into some benefits and privileges. Favors from government often carry with them an enhanced measure of regulation. Anyone may renounce a law introduced for his own benefit. Hope you remember any sin. You can use these. Anyway, no one is obliged to accept a benefit against his consent. A privilege is, as it were, a private law. What I approve, I do not reject. I cannot approve and reject at the same time. I cannot take the benefit of an instrument and at the same time repudiate it. Going down to commerce. Now, I can read each and every line, but why would I when you read them right along and you can have access to the document yourself? I'm only reading ones that actually stand out, and there's pretty much a reason behind why I'm reading these. Maybe I'll discuss it at the end. But this is commerce, and we're reading the Maxims of Law. Goods are worth as much as they can be sold for. Think about those retail stores, Macy's, Bergdorf Goodman, where these items that you would normally find in Kmart, let's say, but has a Louis Vuitton or there's some other French name, is selling for $700, like a scarf in Bergdorf Goodman. A tie one time was $490. Ridiculous, but guess what? Goods are worth as much as they can be sold for. Someone's paying that, so don't knock it. Common sense. One is not present unless he understands. When you go to court and the judge will read the charges to you, and he will say, or she will say, you understand these charges? And if you shake your head in agreement, or if you say yes, then that means you will stand under those charges, meaning whatever they say, you are going to agree with. You are supposed to say, you don't, well, no, let me not give you no legal advice. I would say I don't understand, because I'm not standing under anything in a courtroom. I do not understand. Now, when you say you do not understand in court, it doesn't mean that you don't have the mental capacity to complete the thought or to form an opinion or to be familiar with what's going on in that courtroom. No. When you say you don't understand in a courtroom, that means you do not subject yourself to their will. Anyway, let's move right along. We're in the common sense and we're reading the Maxims of Law. No one is bound to give information about things he is ignorant of, but everyone is bound to know that which he gives information about. And I stick to this hard. I don't talk about anything that I don't know about, or anything that I haven't done myself, or anything that I can't prove. So I'm very careful about what I put out and what I talk about. So you'll hear me talking about do not detain. You hear me talking about discharge of debt. You hear me talking about child support, defenses and things of that nature. You'll hear me talking about authenticating their birth certificate, affidavit of ownership, etc. These are things I've done personally. Parking tickets, traffic tickets, don't pay them. I will never, again, this is the second video, I will never, ever, 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 ever pay another parking summons, moving violations, never. But, you know, that's me. But I don't speak about anything that I don't know about. This is the Maxims of Law, and we're in common sense. No one is bound to arm his adversary. Consent in contracts. He who consents cannot receive an injury. If you agree with it, you accept the damage that comes with it. Contract makes the law. When two persons are liable, and this is a good one, cut out the way. When two persons are liable on a joint obligation, if one makes default, the other must bear the whole. You ought to know with whom you deal. Down to court and pleas. He who does not deny admits. No one is believed in court but upon his oath. In law, none is credited unless he is sworn. All the facts must, when established by witness, be under oath and affirmation. You're going to a courtroom, or you may see court proceedings, and the witness takes a stand and may try to immediately starts talking, and the judge interrupts. Wait. Swear the witness in. Why? Because anything they say prior to being sworn in doesn't hold any weight. And it's, I won't say inadmissible, but it won't be put on the record. You must be sworn in for your words to take effect, to have any precedence, to have any I said right, to any effects. You have to be sworn. You have to be sworn. You in traffic court. Now they audio tape these proceedings, and oftentimes they press pause on the tape, or they may press stop, or they may move the microphone away so you won't be picked up. But you might want to practice on the record, for the record, and let the record reflect. If you cannot, and I've been searching high and low for my own stenographer, not my own, but just a stenographer that I can hire or that I can, retain for my clients and or friends and family. You really, really should bring your own witnesses to court and bring your own stenographer to court. Very important, very important. You get your own records, because in open court or regular court, the stenographer is there for the court's interest. It's not there for your interest. You can always request a copy of the proceedings, but more than likely, you may not appear on those proceedings if you didn't properly record your appearance or your visitation or your statements. This is very, very, very important. You must be under oath. You must be sworn in or affirmed in, because I don't take any oaths, but okay, and this is still under court and pleas. We're reading the Maxims of Law. No one can sue in the name of another. Can't sue for your wife can't sue for you. Court appearances, this is a very big one. This is why we should avoid voluntarily appearing in court. A general appearance cures antecedent, irregularity, I'm jumbling my words. A general appearance cures antecedent, irregularity of process, a defective service, etc. A general appearance. There are several different appearances. You can do a general appearance, you can do a special appearance, you can do a special limited appearance. And just to touch upon appearances real quick, only the dead can be summoned. You summons the dead. So if you've answered a summons, responded to a summons, chances are they are presuming and assuming that you're dead. Unless you did a special limited appearance, which sometimes still grants some jurisdiction, or you did a special visitation. You're doing a special visit. You're not appearing. Or you can appear in writing. Send a formal appearance into the record or file it. Send it to the court ahead of time. And most of the time, you won't have to actually physically be there because your paperwork preceded you. Let's move on. Certain legal consequences are attached to the voluntary act of a person. And here's another big one. The presence of the body cures the error in the name. The truth of the name cures an error in the description. If they sent a letter to you or summons you to court, and they did it in your ens legis, your all capital name, your straw man, and you show up in court, you can say, well, that's not me, that's my straw man. It's in all caps, and not the presence of the body cures the error in the name. The truth of the name cures an error in the description. If they spelled your name wrong, if they put Bobby, B-O-B-Y, and your name is B-O-B-B-I-E, as long as you appeared, that means you were served properly. Unless you contest it. When you contest it, that's a different story. But the error or the presence of the body cures the error in the name. The truth of the name cures an error in the description. An error in the name is immaterial if the body is certain. Who are you, sir? I am such and such and so. What is your address? Da, 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 da. You just prove who you were, or who they thought you were, or who they presuming and assuming you were. You got to be real careful. These courts is tricky. If you don't know the procedure and you don't know the like, would you sit down and play a game of Monopoly if you didn't know the rules? Would you? Let's move on. You got to know what you're getting into. The truth of the demonstration removes the error of the name. Down to crime and punishment, we're reading the Maxims of Law. The instigator of a crime is worse than he who perpetrates it. There was a young lady who persuaded her boyfriend to commit suicide. I'm still waiting for the decision on that one to see how they're going to decide that case. I guess you got to figure out, was suicide a crime in that jurisdiction? If suicide was a crime and the individual injured himself, but he, it's still a crime, is the instigator of the crime responsible? So that's going to be very interesting to see how they decide on that. Okay, no one is punished for his thoughts. Yeah, I wish that was true. No one is punished for merely thinking of a crime. They just arrested somebody because he was boarding a plane, allegedly going to join Al-Qaeda. He was about to board a plane to go join a group. No one is punished for merely thinking of a crime. Was it a crime? I mean, he's aiding the enemy, or he's about to team up with the enemy. But did he actually meet up with the enemy? I mean, there's so many variables that is missing, but these things are done purposely. The programming, just watching television, and how they release information, it's all planned. They're not making any mistakes. They know exactly what they're doing. Anyway, moving right along. He who was once bad is presumed to be always so in the same degree. He who is criminal, he who is once criminal, is presumed to be always criminal in the same kind or way. They arrest you for, I was arrested for unlawful disposal of a summons. So technically, if I loiter, because I loitered before by throwing a summons out a car window, that means I'm habitual. I'm going to do it again. If you rob the store, you're going to do it again in their eyes. This is what they're saying. So be careful of the charges that you accept. Everything is voluntary. Stop volunteering to go to jail, taking plea bargains and things of that nature. Stop hiring attorneys. But that's another video. It's another video. An act does not make a man a criminal unless his intention be criminal. Customs and usage, expressions and words. Moving right along, we are reading the Maxims of Law, fictions, fraud and deceit. Okay, we're in fraud and deceit. Let him who wishes to be deceived be deceived. He who does not prevent what he can seems to commit the thing. God and religion, I'm pretty sure there's one in here I picked up on, maybe not, okay? Governments and jurisdiction. A minor ought not to be guardian of a minor, for he is unfit to govern others who does not know how to govern himself. Minor. What are they talking about when they put minor here? You gotta look it up in a legal dictionary, guys. Minor does not have anything to do with an 8-year-old. And I'll take that back. It does in a way, but it really doesn't in law. And now we're down to judges and judgment. He who spares the guilty punishes the innocent. It's the Maxims of Law. This is law. And yes, this section is law. Okay. Law is established for the benefit of man. Everything is permitted, which is not forbidden by law. The law serves the vigilant, not those who sleep upon their rights. Those awake, not those asleep, the law assists. Marriage. Husband and wife are considered one person in law. Powerful statements here. Husband and wife cannot be a witness for or against each other because of the union of person that exists. I went into this in the father's rights video. And again, when two people are brought into child support hearings and they separate those two people, wife is at the plaintiff table, husband or the male is at the defendant's table. If they are married, immediately assert your rights. They cannot separate you. Now, if you allow it to happen, you allowed it. But if you don't know, you don't know. And so many people did not know. I fought so hard and I got my case thrown out. Miscellaneous. The status of a person is his legal position or condition. That's big too. Officers. Ignorance of the law does not excuse misconduct in anyone, least of all a sworn officer of the law. Possession, it's a big one too. What is mine cannot be taken away without my consent. A person in possession is not bound to prove that the possessions belong to him. That goes two ways. Because you're sitting in a vehicle, an automobile, and a firearm is found under your seat. They consider that that's your possession. You possessed it. It was within your reach. So they're not bound to prove it was your possession. Now, if you are in control of an item and you get stopped by the police, like they do this a lot with in Brownsville, a person is walking down the street carrying something of value, and a good percentage of the time, the merchandise is hot. Good percentage of the time it's hot. They'll ask him, does he have a receipt for it? What do you have a receipt for? I'm in possession of it. Now, see, if you knew your rights, they could have exercised it and said, listen, I'm not bound to prove what is mine. You see me with it, right? Prove it doesn't belong to me. But oftentimes the person gets arrested, and lo and behold, you know, you really give away your rights when you don't know your rights. So there's maxims on, you know, you can't unhealthily enrich yourself, whereas that is stolen property. So wrong in the beginning is wrong in the end. However, you have rights, and unless you know them, you have no rights. So moving right along. Things taken or captured by pirates and robbers do not change their ownership. Things which are taken from enemies immediately become the property of the captors. What's behind these chuckles? Only if you knew. Property and land. When a man has the possession as well as the right of property, he is said to have jus duplicatum, a double right, forming a complete title. This is tantamount the whole theory of authenticating your birth certificate. The whole theory. When a man has the possession as well as the right of the property, he is said to have jus duplicatum, a double right forming a complete title. When you authenticate your birth certificate, you making that document the par is called par, and par with the original, meaning you making it a, I don't want to say replica, but you're making it exactly as the original. Can I say carbon copy? You're making it. It's in the rules of authentication. It's accepted as if it were the original. Now, when you add an affidavit of ownership to it, no one can refute or rebut that that is your possession, that is your property. So you are merging the titles right there. It's forming a complete title. Anyway, the owner of a piece of land owns everything above and below it to an indefinite extent. Right and wrong. This is right and wrong. We're reading the Maxims of Law. An error not resisted is approved. Scriptural. The law is no respecter of persons. I think we're coming up on the end. Got another page to go. Witnesses and proof. There is a maxim of the civil law where everything must be proved by two witnesses. Always bring a witness with you to court. Always bring a witness with you to court. Whether you're going to traffic court or you're fighting for your rights with respect to a civil charge, a criminal charge, you need to bring witnesses. It can be a character witness, someone to speak on behalf of your character and, you know, how you've carried yourself throughout your life, etc. Always, always, always practice bringing witnesses in. We are in the witnesses and proof still. A presumption will stand good until the contrary is proved. The presumption is always in favor of the one who denies. All things are presumed to be lawfully done and duly performed until the contrary is proved. When opinions are equal, a defendant is acquitted. One eyewitness is better than 10 air ones. An eyewitness outweighs others. Pay attention to these maxims, people. The burden of proof lies upon he who affirms, not on him who denies. That is the conclusion of the maxims of law, the maxims of equity, the maxims of commerce. Powerful information. The links to these will be in the description below. I thank you for your time. I thank you for listening. This is Bud-Brownsville. Please like this video. Please share this video. And if you haven't already, please click subscribe. I'm going to get to a point where I'm not saying that every video, but until then, please, please, please. Thank you. And be well.